Now, back to agency law. So we left off talking about agency law last week. And so I want to pick up where we left off and then move forward. So let's just briefly review what we learned last lesson. We had discussed that all of authority comes from some type of agency principle. So we need some type of grant of authority for an agent to be able to bind its principle. And in most cases, in the case here that we're all dealing with, we have some kind of employee or officer of a corporation, and the directors in some way are authorizing that activity. And so we looked at a number of examples of actual authority, express or implied, and actual authority occurs when the principal makes a manifestation to the agent, and the agent reasonably believes that they are authorized. So in the case of actual authority, whether express or implied, we look at whether the agent is reasonable in believing they have authority. And that's distinguishable from implied authority, because implied authority looks at the role of a third person. And in that particular case, when you have a third person, now we look at whether a third person is reasonably justified in believing that an agent is authorized. And so my example here of the consigliere whispering in the godfather's ear, right, is something you see. You see that manifestation. But both of these concepts require a manifestation by the principal. You have to see the principal do something. Either the agent has to see the principal do something, whether that's an express grant of authority through a resolution at a board meeting, or that's an implied grant of authority because an action has been approved in the past, and it would be reasonable for one to think that action would be approved again in the future. And on the other hand, we have the third party who sees an action, a manifestation by the principal, which would make it reasonable to believe an action is approved. But then we have this concept of inherent authority. And inherent authority, well, that's the idea that a person is cloaked with authority, that has a veil of authority upon them, simply by virtue of their position. Now, this is not totally dissimilar from apparent authority, because apparent authority comes from how a third person would reasonably believe an agent is authorized. And so you see someone who's got CEO on their business card, or I should say that they're actually the CEO of a corporation. So there is an action by the principal. That principal actually appointed that person as CEO. So that CEO then has some authority vis-a-vis the third person, because that third person saw that the corporation created a CEO, and it's reasonable to believe a CEO has certain power. Now, the second restatement defines that a little differently and says, well, actually, regardless of the manifestation, without any requirement of a manifestation, a CEO has certain inherent authority, just by virtue of being a CEO. And I find this concept to be a little bit confusing personally, because it seems like it is enveloped by the third restatement. And the third restatement would accord with me, so for what that's worth, the third restatement has done away with the concept of implied authority. But some courts still rely on the doctrine of inherent authority and use that doctrine in order to show that authority has been granted. So let's talk a little bit more about this concept of inherent authority, because we had talked about the other two, and it's worth at least mentioning it, even though it's not really the, let's say, favored view by modern courts. It's not the direction courts are going. You might be in front of a judge at some point who still holds to this, or you might be practicing in a jurisdiction which still has this concept of inherent authority. Inherent authority is a third form of authority that is derived from the status of a person having an office. And the second restatement defines it as power that is derived not from any actual grant of authority, but solely from this perception. And it's based on an intuitive notion that an officer is entitled to act for a company. So, as I mentioned previously, we're kind of moving toward the third restatement, and so this idea has become fuzzier. The third restatement claims to capture this idea that a person who's a CEO has authority by virtue of being a CEO in their idea of an undisclosed principle. And so we'll actually come back to this a little bit later But the idea of an undisclosed principal is that you have an agent and you don't know who they work for. But you see that they claim to be some sort of agent. They claim to be an agent for Priscilla, in our case, selling her horses. And so the third restatement at least claims that this idea of inherent authority is subsumed by the liability of undisclosed principal, and it goes as follows. So I'll talk to you briefly then about the doctrine of undisclosed principal. Section 2.06 of the third restatement. It says, an undisclosed principal is subject to liability for a third party. Now, obviously, an undisclosed principal can't make a manifestation to a third party, right? I just want to make that clear. The nature of a principal being undisclosed means that there is no manifestation, right? You don't even know who the principal is. So there's no manifestation in this case. An undisclosed principal is subject to liability to a third party who is justifiably induced to make a detrimental change in position by an agent acting on the principal's behalf. So we have a couple elements here. We have a rule. So first we have an undisclosed principal, right? We're asking, is the undisclosed principal liable? When is an undisclosed principal liable? When a third party is justifiably induced to make a detrimental change in position. This is also called detrimental reliance. And for those of you who can remember back to your contract stays, detrimental reliance is one of the equitable doctrines. So we have this concept of equity here. So what's really going on? I think what's really going on is the court is trying to figure out, okay, you've got a rogue actor or a potentially rogue actor, and who are we going to hold accountable for this rogue actor? We have a person who is claiming to be a CEO, who actually is a CEO of a company, acting in a manner which is not authorized. Who are we going to leave holding the bag for the actions of that unauthorized actor? Are we going to let a person be responsible for that who is a third party, or are we going to keep the corporation on the hook for that transaction? Well, it would seem that we were going to put the corporation on the hook for the transaction if the third party is justified. And so there's that reasonable justified concept. So there's some equity concept in here, and makes a detrimental change. Right? So they sell land, and now that they've sold it, they lost the opportunity to sell that land to a different buyer, and accordingly they are unable to recoup their difference in profit, what have you. And so the reasoning that the restatement gives for this is effectively this is going to result in only liability in a very few number of cases. This is really a corner doctrine meant to sort of protect in a limited cases where justice requires. And so it's just another equitable doctrine. It's kind of like an estoppel concept. You can think of it as a corporation is effectively estopped from asserting that their agent was not authorized when a third party is justified in believing the agent was authorized and takes action in their detriment. Now, I'm not sure that this is fundamentally different than the concept of inherent authority. It doesn't seem to me, implied authority, it doesn't seem to me fundamentally different. Because why would a third party be justified in taking an action when the agent they have no manifestation by the principal? Right? I mean, if someone came to you and said, hey, I work for Microsoft, I'd like to enter into a contract to buy 10,000 copiers from you over the period of 10 years. Great, okay, so I'm going to go and build in a whole new factory to build a bazillion copy machines to sell to Microsoft. All right, but some guy showed up at your door. I mean, like, are you justified in that without any manifestation by Microsoft, without any assertion of proof? So I'm not really sure how useful this doctrine is, so I'm not going to talk about it much. But really, the fundamental agency concepts you need to be familiar with and aware of are going to be that concept of actual authority and implied authority. This idea of inherent authority, which has been diminished in the third restatement, might be captured by the undisclosed principal doctrine, but it's really hard to say when a third party would be justified in believing that a third party is acting on behalf of an agent without receiving a manifestation. And so this doctrine is very rarely employed. And sort of just it rounds out sort of our discussion there. So let's just focus on what's important then. So actual authority, probably the most important concept. And as corporate attorneys, we're going to spend the next period of time here looking at how to determine actual authority was granted to an agent for a particular action. right? And we want to see the best is express authority. So ideally, we're going to find some express grant of authority that says this transaction is authorized, and we can tell our client we are confident that this was an actual express grant of authority by a corporation to the agent to go ahead and go forward with the transaction, and we want that in writing. Yeah, we want something that is clear and express and deals exactly with the situation here, at least for a major transaction. For minor transactions, what we'll call ordinary day-to-day transactions, we're not going to assert that we have some documentation from the board of directors each and every single time. It's just too onerous, kind of obnoxious, if you will. You've been dealing with the CEO for 20 years, and he goes in and he orders, 5 reams of paper from, your paper company every 3 months. You don't need to see the board certificate every time the CEO buys a couple reams of paper. But that's because it's an ordinary transaction, and so we're going to say that falls under a different doctrine. We also had talked about ratification, and then we talked about the doctrine of apparent authority, right? The idea that a third party sees a manifestation by the principal and therefore thinks that an action is justified. And then we had this kind of minor idea of inherent authority. So before I move on with ascertaining authority, that's all recap from last week. Any sort of just general overall questions about this way that authority flows from the board down to the agents? That was all background and theory. It's all important, but now we're going to apply it. So before we apply it, are we all kind of clear on what all these terms mean? These are important terms of art. You should be able to identify them. You should be able to tell me, is this an actual grant of authority? Is this an express grant of authority? Is this implied authority, inherent authority? You should be able to recognize what type of authority is granted if you think it's present. All right. So now let's ask a different question then. When does an outside party have a duty to ascertain the authority of a corporate officer? When do you, as counsel toward a company, tell them, don't sign that contract yet. Let's make sure they're able to enter this deal with you? Where do you draw the line between listening to an agent and going ahead and fulfilling a purchase order or entering into an agreement? And when do you stop and say, I'm going to need to see some actual proof that authority was expressly granted here? Where do you draw that line?
I would imagine it's not a bright line. I would imagine it's like the ream of paper. If you're going to buy 5 reams of paper, you presume the guy has authority. If you're going to buy, 10 truckloads of paper, maybe you would want to make sure that you...
So, let's try to characterize that in more general terms then, right, Mary Beth? So how would we distinguish? What's the difference between 5 reams of paper and 5 truckloads of paper?
It's the scope or the size of the transaction.
Okay, so size of transaction. That's certainly, I think the intuition's there.
Going off that a little bit, I think a lot of it just has to do with like the risk culture of the corporation too.
Mm-hmm.
You might have, you might have some sort of committee that decides, meeting with counsel or whatever internally and saying, hey, this is how much risk we want to take. Here's the line.
Mm-hmm.
So it might vary between corporations.
How much risk they'll take in terms of risk of the other party not being authorized?
Yeah,
How much you're willing to take on? Well, let's just be cautious. We'll be cautious counsel for now, right? We're not going to take on any legal risk. Let's say we want to preclude legal risk. We don't want to be obnoxious. So we want to walk a line. We're not going to be obnoxious and require information when we don't need it, but we also don't want to let our client get into a deal that wasn't authorized. So, I want to go back to Mary Beth's intuition, and I wouldn't say it's the scope of the deal, because, for example, is there anything inherently different about, 1 truckload versus 5 truckloads? I mean, different corporations might have different needs for paper, for example.
I would say the dollar amount.
So the size of the transaction. So, the only pushback to that is, so let's say that it's I've mentioned, I have a very small company, and I order $10,000 worth of paper. Now, my company makes about $10,000 a year, and I don't print that much. So, to my company, $10,000 is a huge amount of money. Whereas I'm assuming Microsoft goes through that much paper in a day. right? Potentially, right? With their 500,000 employees across the world or whatever. So it can't be just the dollar amount because different companies are going to have different spends, right?
I thought it would be each individual company, but perhaps that's how they set it up. If you're gonna be, this company could say that anything that's over $25,000 you sign, where another company can say anything over 25 million needs this kind of authority.
So what is it? So, but how are we going to kind of classify that, right? That's again, it's the right intuition. But what is the sort of the overall difference then between a 20 for this company, a contract for 25,000 or less is
Relativeness to the normal custom.
normal. That now we're getting there, normal custom, right? And so we're getting closer there. So you deal with someone, they order a truckload of paper every week, and they order another truckload of paper. It's ordinary. Yeah, so that's the distinction we can draw across the board. It's the question of ordinary versus extraordinary. And so the intuition's right. Like a very large transaction from a very small company feels extraordinary, feels unusual, feels unexpected. You wouldn't expect a small proprietor that earns $10,000 a year, some piddly amount, to place an order for $100,000 worth of printer paper. What are you going to do with that? Yeah, but if you have a customer that gets a truckload of paper every week, and they get a truckload of paper the following week, that's more in the scope of what's ordinary. So actually, it's true that it's not a bright line in terms of its application, but the rule is actually a bright line rule. And the rule is that ordinary transactions do not require proof of authority, and extraordinary transactions do. Now, how we define extraordinary could be, what we've done is we've come up with sort of a small list of things that might be extraordinary. A very large transaction is something that could be extraordinary. A transaction for $25 million for most companies is extraordinary. There are, I'm sure, very few companies in the world that routinely enter into $25 million contracts. Right. But whether a $25,000 contract is ordinary or not really depends on who the party is. So instead of drawing a sharp number dollar amount, we look at whether the transaction is ordinary or extraordinary. So how do we know if a transaction, coming from the outside looking in, right, because this is about whether or not we as the third party are reasonable in having a belief, how do we determine as a third party if a transaction is ordinary or extraordinary? One of the first cases that we looked at here is going to be the case of Lee versus Jenkins Brothers. And the second case that we're going to need to look at then is Menards Inc. v. Dage MTI. And these two cases show us two different sides of that coin, right? Cases where we have ordinary or theoretically ordinary transactions, cases where there is extraordinary transactions. So I'm going to give away the punchline because I want to make sure we all are able to see that through the facts. In Lee versus Jenkins Brothers, a court held that the transaction was ordinary when there was a pension award. But the case is useful because it distinguishes what is extraordinary and what is not, and it provided a series of factors and weights for what would constitute an ordinary transaction or not. And then in Menards v. Dage MTI, the court actually flip-flopped, right? We have a trial court that found an extraordinary transaction, and then the appellate court went and reversed that. So both of these cases were close to the line. And as I said, it's not a bright line, but that's the standard. Is it an ordinary transaction? Because if it was ordinary, then the third party is justified in believing that the agent was authorized. Because an agent is authorized to conduct ordinary business, at least a CEO, or we're talking a CEO, a president, a major official here. But if the transaction is extraordinary, well, then it's no longer reasonable to believe that that transaction was authorized without some additional grant of authority. And then it becomes a question of defining what's ordinary and what's extraordinary. Now, before we get into this, if you're counsel for a company and something might be extraordinary, what should you do? You should ask for proof. I mean, we don't want to be in a situation as corporate counsel that we're right on the line and we're going to go to court over this and potentially lose at trial and win at appeal. I mean, that's not a good solution for our client. What our client wants is not to go to court in the first place. And so, counsel should take a much more conservative view of what constitutes an ordinary transaction. Counsel should be asking for evidence of authority in a broader range of transactions than what is absolutely necessary if you were to litigate it, right? We're not trying to get right to the line as corporate counsel. So as a practice point, we're going to ask for proof in anything that could be extraordinary. But as a litigation matter, as a ex post matter, right after the deal is done, when will a court find for our client, who was the third party to the transaction, when will a court say that the principal does not have to follow through with the deal because the agent's not authorized? It turns on this issue of ordinary versus extraordinary. So what happened in Lee versus Jenkins Brothers? I know 30 pages of reading over 3 weeks is really a heavy workload here, guys. Sure. You already got your gold star, but, well, actually, let me see if anyone else can answer this one. John, did you have a chance to read the case?
The president of the company offered a pension plan that was outside of the norm to the executive as a recruiter.
Yeah, he offered a pension plan, right? And so what was sort of unusual about this pension plan? Yeah, that's weird, right? That's kind of weird for a company. Why are you giving a life pension to a guy? He's 60 years old. He might live a while, and this was a $1,500 a year pension. So the first question is, it's not going to be a problem if the board actually authorized this. Did the board actually authorize the grant of this pension? Did they have a meeting and say, hey, let's give this guy $1,500 a year for the rest of his life?
I don't think
They didn't. Right? If there was a board resolution somewhere in there, that would be the end of that. But they didn't have that meeting. We have sort of a rogue president. Yeah? And so the issue is whether or not President Yardley, in this case, had the authority to make this pension grant. So did he? Well, let's take a look, right? We actually just answered the question. Did he have actual express authority? Was he given... So where do you get actual express authority from? Yeah. From the bylaws is one source, right? And so did the bylaws in this case say the president shall have the authority to grant pensions to whoever he feels like? Of course it didn't. That's not something you find in bylaws. Bylaws can grant authority. You have a copy of bylaws from the formation deal that we did together. But no, there's no actual grant of authority to give pensions or things like that. In fact, that's not part of the scope here. Where else could actual authority come from? Sure. Yeah, John. A resolution in a meeting. Yeah, the board can sit as a board and engage in a meeting and come up with resolutions which are then going to be binding on the corporation. Did that happen here? Did the board have a meeting and say, let's give a pension to Yardley? No, there's no grant of authority there. So those are our two major sources of authority. They could also potentially be in the certificate of incorporation. As we discussed, it's like a publicly filed document. It's going to have pretty limited provisions in there. So was there any implied authority? How could implied authority come into this case? What would that look like? Yeah, Alexander.
If the president was constantly authorizing pension plans?
Great. If he was constantly authorizing pension plans, or not even necessarily even constantly, some even less than that, if let's say he had given pensions to 3 or 4 or 5 other people, I don't know the exact number, but if he had granted pensions to 3, 4, or 5 other employees, and the board said nothing, or if the board in fact told him to grant a pension to employee X and employee Y and employee Z, let's go with A, B, C because I'm getting to D here, right? The board says grant a pension to employee A. President goes fine. Board goes grant a pension to employee B. Board goes fine. Grant a pension to employee C. Board says fine. Employee D comes around and says, can I have a pension? President says yes. That could be implied authority. All right, we saw the example with Priscilla. And he sold the horses before, and so he might have implied authority to sell them again. He took a check before. He might have authority to take the check again. Did that happen here? Was this a company that routinely authorized the grant of pensions, lifetime pensions? No. No, this was an unusual circumstance. And so it did not appear there was any inherent implied authority in this case either. So then we have to then ask, we put ourselves in the position of the pensioner, the person who received the promise, and in fact we kind of superimpose this concept of a reasonable person above that. What would a reasonable person have to say about that? Would a reasonable third party think that President Yardley had the authority to grant a pension? Well, how did the case come out? We can work backwards from there. Did the court enforce the contract? Did the company have to pay the pension? Or did the company find that the pension was unenforceable? Yeah, go ahead.
The contract was enforceable. The pension was valid.
The pension was valid. And so what can we infer from that? So we know there's no express authority, and the pension was valid, and hint, the court did not discuss inherent authority here. So there must have been some authority. What do we have left? There's apparent authority. And so here the court must have said that it was reasonable for a person to believe that Yardley had this power. And that is essentially the same thing as saying a third person would believe this was an ordinary transaction. Because you're only justified in believing a third party has authority when the transaction is ordinary, right? Otherwise, you would have to ask for some additional grant of authority here. And so apparently I should suggest maybe go back and take a look at the case. It doesn't seem like some of you are caught up on that one. But take a look at this case, right? Because this case shows precisely the issue that we're going to be dealing with on the exam, which is whether or not it's reasonable to believe that there was a grant of authority. So take a look at that one. The case did not discuss the inherent authority concept, but it steps through whether or not there's actual authority, finds that there's not, and then has an extended discussion of whether there's apparent authority that has to do with the reasonableness onto the third person. So take a look at this case and try to understand whether or not there was, in fact, apparent authority granted. In fact, this case does even more than that for us. It actually goes through a set of factors under which it's reasonable to believe that apparent authority is granted. So it's a super useful case, because now we have a set of factors that we can apply to other cases. So what are those factors? The Lee Court presented 8 separate factors here that we should be aware of, and we can cite to these. There's not a lot of case law in this class, but here at least we have something. We have 8 factors which show whether it's more or less likely for a third party to be reasonable in believing that an agent has been granted authority by a principal. Yes? Sure. Let's just go through them. I have them listed here too. Yeah, I'll put them. Yeah, let's have a discussion format. All right. So what does that mean exactly? Let's just have a discussion about it, right? So the nature of the contract. And so what does that mean? Yeah, or anyone else can. It's sort of an open question, right? What does that element mean?
The item sold, the quantity.
Yeah. So that's kind of getting the idea, was this an expensive contract, a cheap contract? Was this something they usually sell or usually enter into? A company that routinely employs people? Apparently here, the nature of this contract was within the scope of what you'd expect a company to offer. And we're going to get back to this right in Dage v. MTI, where a company makes little potentiometer widgets or some kind of machine, and they sell a bunch of land. So the nature of the contract different from the business. Here, maybe not so different. What's the second factor? Okay, so who was the officer in this case? Yeah, the president. Basically the CEO, president. So that's going to be your best evidence there. I mean, you have the janitor doing this. I mean, no offense to janitors, but they usually don't bind the company in granting pensions, lifetime pensions, right? I mean, fair enough? If the janitor says to you, hey, the company's going to pay you $1,500 a month for the rest of your life, is it reasonable for you to believe that guy? Do you think that janitor has been granted authority by the corporation by virtue of being a janitor? Does he have authority to grant lifetime pensions? Probably not. Then you move up the chain. How about the vice president of employee relations? It's looking more likely. And how about the CEO? That's the CEO president, kind of the ultimate officer. So the higher the level of the officer and the more specific the officer's role is in dealing with these type of contracts, the more likely we're going to find authority. All right, what's our third factor? Right, usual manner of conducting business. And so, if this is a company that is routinely engaging in this type of practice, right, similar kind of factor, going to make it more reasonable to believe that it authorized this as well. Our next factor?
Size of the corporation and number of stock.
So this was sort of to your point, if we have a larger corporation, maybe they sneeze 20 million bucks, right? But you have a small sole proprietorship, $10,000 might be a huge contract for them. So whether or not it's reasonable to believe that the principal authorized a transaction has to do with the nature of the principal. And it's a really massive multinational corporation with a bagillion stockholders, and it's a small deal, right? If the nature of the contract is such that it's minuscule in relationship to the overall size of the company. Not that it's a small deal in itself, but that it's small in relationship to the size of the company. That might give you some comfort that it was probably authorized, or at least you're reasonable in believing it. All right, our fifth factor.
Circumstances that give rise to the contract.
Were there preliminary negotiations? Was there, a call, like in a newspaper, for a request for bids on a certain type of deal? Right, and so if the circumstances are unusual, if it smells fishy, if this is sort of weird and out of the ordinary, once again, that's going to make it less reasonable to find that there was authority here. And if it's something that the circumstances are normal, and that kind of goes, I'll just kind of flip through them. The other ones, that kind of was the contract reasonable, the amounts involved in relationship to the size, and who the third party is. And so all these, what do they all boil down to? These are all 8 factors. We can apply them if we really care about, running through a factor test. But what's the essence of what these are all getting at? Yeah, Megan. Is it ordinary or not? These are simply factors of testing whether or not a particular contract is ordinary or not. Because if it's extraordinary, it's not reasonable to believe it was authorized. And here in this particular case, the court ultimately held the promise was not extraordinary. A couple, major reasons: it didn't expose the corporation to significant liabilities. This wasn't a big deal for this corporation. It wasn't going to, look, the guy, $1,500, what was it, $1,500 a year, $1,500 a month, whatever it wasn't really that much money for a company of this size. And so as a result, it was held to be ordinary. And in a way, this is just shifting the risk. Do we want to put the risk on the corporation for having a rogue agent, or do we want to put the risk on the third party for falsely believing a corporation? Well, I think part of it too here is that one of the parties was some guy who believed the principal, believed the president, and quit his job over it, and went out of work. And the other is like a major corporation. So maybe there's a fairness element to this too, but I think the court here sees that it's reasonable to enforce this particular contract for those reasons. It didn't affect future policy. It wasn't binding them. They just had to pay the guy a reasonably small amount of money relative to their overall position for the rest of his life, which, I guess they assumed was, a reasonable amount of liability for this company to assume. Any questions about our kind of first case here? Do you see how this plays out? Right, this is a case about testing apparent authority. And so you might be asked about this. You might be, there might not be express authority. Do you think you need to get express authority? This should answer that question. All right, our next case was Menards Inc. for Stage MTI. And so we have a similar type of situation here in that we have a president who was acting without actual authority. So the question then is he going to be bound by this transaction? So what are the facts of this case? Mary Beth.
Okay, Dage was selling 30 acres, I believe, of land in Menards for
Yeah, exactly 30 acres.
1.4, 1.5 billion, and it was.
Let's actually I want to get to those facts, but we always want to, right, let's look at our factors. One of them is sort of the nature of the parties. So now I'm going to have to step through. This is the only problem with a keynote. It kind of makes you do, okay, so I can skip that way. So what does Dage MTI do?
They make some sort of electronic.
Yeah, as far as I can tell, they make this thing.
Yeah.
They make this thing. I don't know what this thing does. Anyone know what this thing does? It has black level, gain, enhance, gain and black can go auto. Cool. Some kind of widget.
For TV?
Maybe. I really have no idea what it does, but I'm pretty sure they're not like a company that routinely buys and sells land. And what about Menards? What's their business?
Discount store.
Discount store. Yeah, and so they actually do tend to own, right, because they're going to buy land on a more regular basis because their nature is to sort of own properties. So, and who are the key people involved?
Sterling?
Yeah, we have this guy, Arthur Sterling, and why does that matter? Because Sterling has been operating this company as if it was his own for a long period of time. And Sterling had been operating this company without board oversight for many, many years. So, what happens to the governance there? We have this new guy come in, a new investor. And this happens often. This is sort of a very small story of shareholder activism. You have a company run badly, because remember we talked about all these issues about capture and about empire building, about all the reasons why CEOs are going to run amok and cause trouble. Okay, so you got a CEO running amok and causing trouble, but there is a way to discipline them. A new shareholder can come in. I mean, that should drive the stock price down. If you got a CEO who's doing a crap job, then the stock price is probably going to go down. We've seen this in the public markets. We've seen this in the private markets. And we've seen this over and over in this class. So when the stock price goes down, a value investor might say, well, this company's undervalued. They make these really cool widgets that have some kind of value, and they own some land which has some value. So let's go ahead and buy this company and get management to change, right? And this is activist shareholding, activist investing. So a new investor, Kerrigan, buys in and puts himself on the board and tries to rein in Sterling. He's aware that Sterling is a rogue agent. But does that work, Mary Beth?
Well, in the end, the outcome of the case is that Menards gets the deal, they get the benefit of the deal. I mean,
Yeah, that is the punchline, that Menards ends up winning this. And I think this is by the way, broader picture here. Despite all these factors, whatever, courts tend to hold corporations reliable for their agents. It's just a question of risk shifting. I mean, who are you going to make responsible at the end of the day? The company that has more control, right? And they should be control. I mean, really what they should do, if you really want to rein in your president and he just won't listen, you fire him. Yeah, it's a pain, but otherwise, you should be liable. Well, anyway, Sterling is running around, and he's apparently really, really hot to trot on this idea of selling some land. So he gets approached by Menards Inc. They want to purchase this land, and Sterling does what he should do. Right? What should a good agent do when presented with an extraordinary transaction? Go to the board, ask for approval, right? You're not authorized to do this, yeah? So, I mean, you should ask for permission. This is not a beg for forgiveness kind of idea. You don't have authority in the bylaws to engage in extraordinary transactions, and this was a huge amount of land for this particular company. So he does what he should do, and he goes to the board. And then what does the board do?
They say no.
They reject it.
Specific provisions.
They specifically reject this deal, and they tell him to drop it. Or first they tell him to renegotiate it under certain provisions. They tell him, we're not going to take this deal, right? So Sterling calls him and says, make me another offer. Make me a better offer. My board won't take this deal. Now that's sort of interesting in terms of the outcome, because at this point, wouldn't you think Menards is aware that the board is not approving of this deal? I think if you think about that carefully, it really goes to the point of how much courts are going to try to impose the liability on the corporation for not controlling their rogue agents. So Sterling solicits a second proposal and receives an offer to purchase not just 10.5 of the acres, but the whole thing. So what does he do then? So then does he go back to the board? He doesn't go back to the board, right? I don't know, maybe he thought he was doing their bidding, or maybe he thought they wouldn't approve it and he knew what was best for the company. But he doesn't go back to the board, and instead goes ahead and follows through with this and negotiates the deal with Menards. Now, this is a close case because, right, Menards knew that the board rejected the first deal. So what should be going on in their minds? Well, I guess the court disagrees with me, but it seems that a big company like Menard with a whole team of lawyers should be saying at this point, not sure this transaction's authorized because you rejected the first one. I'd like to see some proof here, but that's actually not what happened. Although I think there were some other facts here that made the difference. The transaction was not actually approved. In fact, just a kind of a quick question, was there actual authority? No, the opposite. There was, I don't know what you call it, actual disauthority, like an express grant, an expression of no authority. You cannot do this. Absolutely no express authority. Was there implied authority? No, entirely for the same reason. I mean, you were told, don't engage in this transactions. So even if there was some kind of potential for implied authority based on prior actions, that should wipe it off the table. So now we have to look at apparent authority, and the court does seem to evaluate that. And as Mary Beth mentioned, it ends up saying that this transaction was authorized and approved. But when exactly does Dage MTI complain about this? So it gets closed, right? Sterling negotiates it, signs it, the deed gets transferred, the land gets transferred.
It's like 100 some days or something.
I think it was 4 months, over 4 months. So it was 100, must be more. I have here over 4 months. So it's 120, 130 days. Now, a lot can change in 120 days. I mean, I don't know if you've seen with housing prices or what have you, but 4 months is a lot of time for land. And prices can really change in that period. All right, so let's do the analysis like you would if you were asked a question like this. And the first stage in this is always going to be, was there actual express authority? Because that's our best source of authority. We answered this question, but just if everyone is following along at home, is there actual express authority here? No, absolutely not, right? We have no board meeting that says you can sell this land. Was there implied authority? No, the opposite, right? The board said, don't sell this land. To the extent that there was some implication he had power, it was wiped away by that and expressly denied. So then the question is, was there apparent authority? And how does the court rule on apparent authority here?
Please. No, because they knew that Sterling needed it.
Yeah, so they knew he needed approval. And so what does apparent authority require? We still need what? A manifestation by the principal that is reasonably understood by, in this case, the third party. In actual and implied authority, we need a manifestation by the principal. In the case of actual authority, it has to be reasonably understood by the agent. In the case of implied authority, apparent authority, it has to be understood by the third party. So was there a manifestation by Dage MTI that would be reasonably understood by Menards to provide authority to Sterling? The only manifestation made from Dage MTI to Menards is saying, we reject this deal. So we don't have apparent authority here either. So this court now gets into the concept of inherent authority, and we've run through our list, right? We're out of options. There's no other source of authority here, and we know that the transaction went through the court. So can we then surmise that there was inherent authority? Yes. Why was there inherent authority? Well, I would say that we have to look a little bit more about that statute. So let's take a minute then, look at that statute, see if we can understand how it was found here. And we looked into the second restatement of agency, which again, it's not current, and not all courts will apply it, but something good to know about. And it says that an inherent authority comes when an agent is going about a usual or incidental act. So meaning going about their usual course of business, things that a CEO or president would usually do, where the third party has a reasonable belief that they are authorized. Now this is weird. I mean, I have a little trouble on this one, on this case. I don't know about you guys, but why would it be reasonable for Menards to think this was authorized when they just heard that that the board rejected the deal? But that's the second element here. Yeah.
You guys come up with something different, he must have done something to manifest that there was still some interest in this deal.
He did exactly that. So maybe it was your hazy memory, but your intuition's right on. Sterling said he was duly authorized. Sterling went out of his way to try to convince Menards that he was authorized. John?
Wasn't there a statement in the contract too that said that he was acting on behalf of the board and because of his position, that's why the board?
Yeah, he put that in the contract. Now, it becomes a chicken egg problem a little bit. Like, it's in the contract, but the president who's running rogue is the one who wrote the contract and signed the contract. So it's a question of how reasonable it is to rely on that. But he did make that assertion. Yeah, David.
It says here that Sterling later confirmed that he had the authority from the board to proceed, so maybe they thought to proceed and approve the deal, I guess.
Yeah. Yeah, so, but it was kind of a bold-faced lie. I mean, essentially, you've got an agent who's running so rogue that he is lying about the fact he has authority. And so this is where the doctrine of inherent authority kind of comes in and says, is it reasonable to believe this guy? Well, I mean, he is the president. He's been running it for a long time. He says he has authority. He put it in the contract. He might be a slick character who's spinning a yarn. He seemed to lie about how much authority he actually had to try to close the deal. So maybe it was reasonable in this case. Although I think the fact that it was 4 months was a major factor in how the court found this decision. And then the last element for inherent authority is that the third party had no notice. And the court finds that Menard had no notice of the consent resolution proposal, that Sterling's authority was limited. Okay, I mean, I don't know. I think the court is stretching here. I think we're seeing a case that's at really the outer limits of this doctrine. And I think a large part of that is because there was this 4-month delay afterwards. So, sometimes bad facts make bad law. It certainly shows an extreme kind of case where a president was really going out of his way to try to push a deal through that was definitely not authorized. And we have a company that was really ineffective at reining him in. So I think in some ways the court is punishing DAGE MTI for having such a bad job of monitoring their agent, right? Because that's the responsibility of DAGE MTI. This guy could do a lot of damage. And we're not going to just let society absorb all that damage. We're going to have that damage flow back to DAGE MTI. And their shareholders, they really should fire this guy if they want to protect themselves against him. But, there's a huge problem with this outcome. And so I think that 4 months delay, it reminds me of an estoppel kind of argument. That, you sort of, maybe there's an argument here, and the court did not expressly bring this up, but maybe in their minds they were thinking, well, even if there wasn't inherent authority, there was estoppel by silence, or there was ratification by inaction. But because there are other doctrines that we could use to impose the liability on DAGE MTI. It doesn't feel entirely wrong here, but it does kind of push the limits of the doctrine. And the dissent, I think, brings that up in particular and says, okay, now what? Okay, great. Thanks for this case, guys, because now how do we know, how do we actually control presidents that are running rogue? I mean, what do you have to do? I think the answer to the dissent is you fire the guy when you know he's running amok. I think the problem was they knew he had a tendency to run amok and they didn't fire him. They knew that he was trying to get this deal and they should have called Menards and said, this guy's not authorized to do it. And they should have certainly acted in much less than 4 months' time after the deal closed in order to get the protection of the law. So I think there's a lot of bad facts here in the favor Menard, but it gives you a chance to see how this concept plays out in the law. So those were your two major cases, and again, you should look at both of them in some detail. If you haven't yet, you should refresh your recollection afterwards, because these are the only two cases you'll have that step you through whether or not a transaction is ordinary or extraordinary, and whether or not there will be apparent authority. And if you're presented with a question where there is a lack of express authority, which is a commonplace topic here, and the question is whether or not the transaction is valid, you need to understand how to apply the doctrine of apparent authority and be at least familiar with the concept of inherent authority so that you know whether or not one party or the other will be held liable. Yes, David?
Should we, on the test, should we try to do it like the court did and try to find like other things like silence by estoppel?
Yeah, we didn't spend a lot of time on those doctrines because we're kind of going for a little bit more breadth than depth in there. Absolutely fair game to mention, and that's sort of the kind of, check plus kind of material. But I want to focus on, is there actual authority? Is there apparent authority? A sentence on implied authority, and, really minor, but, worth mentioning, estoppel and silence are sort of the other two ways that a court, because that doesn't show an actual grant of authority. That simply shows that a court will not allow a company to disclaim liability, but it's not really a true grant of authority. And really what I want us to focus on is to understand the situation where we need to ask for more authority, for more proof of authority. Right, so what do these cases do? They also highlight what is an ordinary and extraordinary transaction. Both of these transactions were right on the line. And if you saw a transaction like this, and you were Menard, or you were the Lee, and maybe less so Lee because he's just a guy. But if you're Menards, like a team of attorneys, and you have these facts presented to you, you really should be investigating authority, right? And so, really, what you're looking to do is: do you understand enough about actual and apparent authority to know when you have to ask for more documentation? And then do you know when you've required and requested and received enough documentation to feel comfortable that there is in fact authority and you can go ahead with the transaction? Right? That's the work of corporate attorneys in verifying transactions. So we have both on the side of the company that's trying to get the transaction through, making sure it's approved properly, and then evidencing it. So the next question then we ask, now that we've seen scenarios that we have situations that may not have authority, in those scenarios we want to ask for evidence of authority. And so how do we do that? Well, what are the sources of authority? Right? And we talked about a few of these earlier. One of those, and the major one, for any kind of specific transaction, we want to see a board resolution. What do those look like? They look just like the organizational resolutions that you saw. They can either be by unanimous consent without a meeting, or by a majority vote, usually with quorum, at a meeting, duly noticed meeting. But we want to see that board resolution. And moreover, we want to know that board meeting was held properly, or that unanimous consent was done right. And so we have to understand how those things work. I mean, you have to be able to be on both sides. You have to know how a board meeting should be held to know if a board meeting was held properly. There could also be statute that grants certain authority, and so we could look to that. We're not going to talk about any particular statutes in this class, but you should be aware that there could be a statute that grants authority in a particular case or imposes liability in a particular case. The charter could grant authority. It has that power. It's a public document, so it's a strong grant, but most companies don't put those sort of things in the charter because it has to be amended publicly. It costs money to file or refile. They might put it in the bylaws. The bylaws are going to have a general description of what the officer can do, and so that's a good source. So you can ask for a copy of the bylaws to see if a person is authorized or not. And, evidence that the corporation allowed this action in the past. Now, that's sort of your weakest source, because evidence the corporation allowed it in the past, well, the corporation could argue this is a little bit different. This is not the same situation. Different rules apply. So we don't really want to hang our hat on that. And then I think to John's point, okay, so it said in the contract that he was authorized, but how do we know that evidence is authentic? How do we get authenticity of evidence of any type of board document? So Sterling gives you a copy of the bylaws, and it says, paragraph 10b, President, the President shall have authority to bind the company in all sales of land. I mean, he could doctor that up, right? How do you know that that's real? Yeah. The Secretary seals it. So that's exactly right. So we have this other check, which is that we're going to ask for these documents to be verified by a different corporate officer. Remember a month ago or so when we went through the process and we created Rigor Mortis Incorporated and we set the Secretary to be different than the President? Why did we do that? Because that way we have two different people, and so we are going to get authorization from the Secretary that the President is approved. We're going to get a certificate from the Secretary that a board meeting authorizing the President was held. And so the secretary of the corporation or another bookkeeper is going to certify the documentation. That's going to provide an additional fail-safe. Now, as we're going to see, we end up really going down a rabbit hole that we can't ever get to the bottom of, because how do we know that that secretary certificate is real? I mean, we could go to some level of absurdity here. But just to get to the punchline on that, courts generally recognize that the secretary certificate is good enough so long as you're aware that is actually the secretary of the corporation. So I think this will start to make sense as we run through some hypotheticals, and this is a chance for some of you to participate a little bit here. So let's talk through some of the hypos here, and we'll start with sort of stage one as we work through a potential contract with constructs. Go ahead and read the fact pattern, and then we'll talk about this. Sir.
So I'm not sure, how courts would be, what they would be looking for, but to me, that probably wouldn't be sufficient. To me, I would probably want maybe like a credit rating or something. That would be my first instinct.
Right, so, well, first off, I mean, what's going on in this transaction? What is the nature of this transaction, Paul?
Employment, a job, they're asking for a job to make a building.
And they're going to get, so we have a contract, right, to supply supplies, and we have the supplier to the supplier going to guarantee it. So I think, to your point, John, Alex, the transaction is a little weird, right?
Yeah, there's a conflict there.
I mean, I think the first question is, why the hell is the equipment supplier guaranteeing this? Like, why, I mean, just on a normal, I mean, does this look ordinary to you? If it does, it shouldn't. I mean, it's just weird. Yes? You could, yeah. So there's lots of ways to get insurance, protection, what have you, and so we could ask for lots of things like that. But let's say we're going to be comfortable with a guarantee if it's real. But yeah, there's other ways we could protect ourselves from a supplier or an upstream producer who might not be able to make good on their contract. But I think fundamentally here we have to ask ourselves, why is the supplier giving a large financial guarantee? Yeah.
I mean, wouldn't it benefit them if they get the job? Like if Home Supplies gets the contract, then Big Machines is probably going to benefit from that.
Maybe, but I mean, guaranteeing a huge loan for equipment, for supplies. I mean, I think there are some colorable reasons why Big Machines might do it, but it's not normal, right? This is not ordinary, and so I think we start from that position that this is not so normal. So plus, this is who told you that Big Machines is going to guarantee this? Constructs did. They just orally told you. They just told you, okay, we want to have a $10 million contract with you, and by the way, this company, Big Machines, is going to guarantee it. And you're corporate counsel, and you're just going to say, oh, fine, that sounds great. Sure, no problem. I totally believe you. You can't do that, guys. You got it. This is the whole point of this is ascertaining corporate authority. This is you see that says 8.1a? There's a B, right? So this is clearly not the end of the hypo here. Yeah, and so what's going on? It's an odd transaction. There's no basis for it. It's an oral representation for a big deal. We care about getting paid for our work, and so we have this company which is offering a guarantee. We never even heard of them. So I think at a minimum, we might want to see the guarantee in writing, right? I mean, what are the terms of it? All right, so I think we start asking there. Okay, so you say the Big Machines is going to guarantee this. For one thing, I just taught the statute of frauds this morning in contracts class, and this is called a surety, right? S-U-R-T-Y, suretyship, and contracts for suretyship need to be evidenced by a signed writing. So I know, it was like last year, so it's like, but statute of frauds requires this guarantee to be in a signed writing or it's not enforceable. So at a bare minimum, just to comply with basic contracts principles, you should be getting this guarantee in writing. So that should be your very first question. Paul?
Well, there hasn't even been a guarantee yet, though.
Well, there's an oral, we have constructs saying that Big Machines is guaranteeing.
Big Machines have to send them the guarantee, which that hasn't happened yet because they just said they will in the future.
They will in the future. Right, so it's not even right. That's actually even more so. That they will, don't worry about it, we'll get a guarantee, I'm sure. We have this oral statement that we will get a guarantee in the future. Not even, you're right, they're not even saying we have a guarantee now. Yeah.
The only thing that would make it maybe less weird is if Big Machines was owned by Constructs.
Okay, sure.
I think maybe then they could give some sort of guarantee, like showing their, assets.
Oh yeah, if there's one common parent and these are both just subsidiaries,
I think
yeah,
that's the only way to make it
unweird. Yeah, well, not under the facts here. They're just two separate companies running their thing in their world. So let's go ahead and get that guarantee. And as I mentioned, other law kind of comes in here a little bit. It's required, the guarantee is required to be in writing under the statute of fraud. So at a bare minimum, we should remember our 1L contracts lesson and get the guarantee in writing. So we get the guarantee in writing. And now the question is this satisfactory? Or what further questions would you now ask? Yes.
Or you'd have to go through the whole thing with Big Machines, like, does Mr. Kraft have the authority to buy Big Machines? Does Mr. Kraft, is there any other officer? Because Mr. Kraft has 2 offices, so that's a little, you might want to have another officer's concurrence on this deal.
Yeah. So who is George Kraft? I don't know. Do you guys know who George Kraft is? Do you? Pat, do you know who George Kraft is? You familiar with this guy?
I haven't met him.
You can't vouch for George Kraft. All right, Paul, you want to vouch for George Kraft? You know this guy?
No, but couldn't you just ask for a guarantee on his guarantee?
So from who? Who are you going to ask?
From the board of Big Machines.
Okay, we could ask for a resolution that says that he's authorized to do this, but couldn't this be just like Sterling? Couldn't this be another vice president running amok in the world? There's even something more fundamental we don't know. Yeah.
How much is the project worth? Like, if the project's $100 million, they guarantee it $10 million, isn't going to do that much.
So we're kind of evaluating, so that's sort of getting to the apparent authority question. And we want to find express authority first, right? We want express authority. I think you're right. I think you're right that we could try to see if there's apparent authority, but we've already sort of determined that we want some evidence of express authority because this is weird enough that's probably not going to be, and we don't want to take that risk. I think you're right if we're doing the actual authority, the apparent authority analysis, that we would go there, but there's something more fundamental we don't know that I think really raises some huge questions here.
Who's Big Machines?
Who's Big Machines? Is that even real? Is Big Machines even a real company? I mean, who sent this to you? Construct sent this to you. Construct sent you a guarantee from someone named George Kraft you never heard of, who's allegedly the vice president treasurer of Big Machines Inc., which you've never heard of. So how can you find out if Big Machines is real?
Go to the Secretary of State of Delaware and look them up.
Look them up, right? Now, we don't actually know. We actually do know. So it does say under the state of Delaware. So we know we can go to Delaware, we can go to the Secretary of State, look them up. Now, if this is a public company, we can also go to the SEC, and that's going to really help because the SEC has a lot of public filings. We briefly looked at Edgar in a class a couple weeks ago, right? Edgar, everybody, right? The SEC's database, and what's on there? All the filings, the 8Ks, the 10Ks, the 10Qs, a bunch of other stuff, and it will include who are the officers. And we can look in there. Public companies' officers are publicly available, so we can find out. But,
I have a question.
yes,
So you could look up basic financials in there,
yes,
but if it was a private company, and
nope.
what would you do? I mean, could
Well, there
you
are some
find out
databases for
whether
that, yeah.
Machines has assets, or, there's the financial wherewithal to guarantee $10
Sure. There are some databases that you can subscribe to that have some of that data, PitchBook, Crunchbase, that deal with private company stuff, but much less reliable. No, so if you don't have the public company, you want to ask, if it's a public company, you don't have to ask for as much authority. It's just more clear, and you can have more reliability once you're working with an officer there. Private company, a little bit more. Other questions, again, kind of going back, why is Big Machines doing this? And why is the guarantee coming from the vice president or the treasurer? Is that something that a vice president or treasurer usually does? Where would we find that information? So what do we want to see next? We want to probably see whether or not the vice president or treasurer is generally authorized to do this sort of thing. Which document will we then ask for from Big Machines or through contracts from Big Machines to find out what the vice president or treasurer's general responsibilities and authority usually is? Yeah, Cassie.
The bylaws?
Yeah, let's take a look at the bylaws. Exactly. Because the bylaws are going to provide some general scope of authority for these general positions, right? That's an actual express grant of authority. And so we get a copy of the bylaws. Here's what they say. Does this do it for us? Yes, Sam.
I would say no. I mean, he has the authority to sign checks, but I don't think he has the authority to spend money.
Yeah, it doesn't say that, right? I mean, we have, evidence of indebtedness, but can he create new debts? Can he create new guarantees? I mean, does this language say expressly that the vice president or treasurer, or just treasurer, does the treasurer have the authority to cause the company to be liable for the debts of another company? It doesn't say that. He can sign checks, he can draft bills of exchange, whatever those are, and other instances of indebtedness, but this is definitely not enough here, right? I mean, this is definitely not going to be enough to show the authority to be a surety, because that's not written here. Now, it could be implied, but we don't have a course of dealing with Big Machines, and we don't see what the treasurer has done in the past. So we also don't have evidence of implied authority. And, like we were talking about just a moment ago, we're not going to just hang our hats and rest our case on apparent authority. It's just too nebulous, and it's about reasonableness and whether we reasonably believe. We want to really protect our client in major deals. So we're going to have to keep digging. There's also some things we still don't know from these bylaws. What do these bylaws still not tell us? Is George Kraft the treasurer? Is George Kraft the treasurer? We still don't know that. We don't know if the treasurer has the authority to do this, and we don't know that George Kraft is actually the treasurer. So we have a number of reasons for remaining concerned. And so, again, the thought process here, let's ask for additional information. We are still not satisfied. So let's go and tell constructs that we're not satisfied and ask for some additional information. By the way, we've looked at the bylaws. What is another source of authority that we might ask for next? And this was brought up before, but just as a reminder, what other authority can we ask for? Sure, John. A board resolution. That'd be great. We can go next to the board resolution. Yeah, so let's take a look at the board resolution. Is this enough? All right, so, yeah.
I was gonna say that you would need to know whether or not that was a valid meeting.
Yeah, we don't know if the meeting was valid, right? Does the board, this just says resolution. We actually don't even know that this was at a meeting. Does it say meeting anywhere? Right? So how does the board make decisions? At a meeting, or if there's an exception to the meeting rule. What's the exception? Unanimous written consent. That's our major exception to the meeting rule. We don't have evidence of either here. There's no indication the board met. Even if the board met, what would we have to know about that meeting? Mary Beth.
How many people, is it a simple majority? It says constituting majority of the board. Is it a simple majority? Is it a two-thirds majority? What is the governance of the big?
Yeah, so in the bylaws, we're going to, so, I mean, even before we get to the vote, what do we have to know about the meeting? Yes, please.
It doesn't say that it's for the home supplies contract that construct corp that they're.
Yeah, it doesn't, so ideally, this would have that guarantee attached as like Exhibit A. But we're not even sure this is a valid meeting. What do we have to know about the meeting? What's the first thing in advance of the meeting that we need?
If there was a quorum?
Even before the quorum. John?
Notice.
Notice. It has to either be a regular meeting or a special meeting requires notice. And the amount of notice will depend on the bylaws. So we have to have something that says that the meeting was duly noticed. Or we have to have language that it was at a regular meeting. So we need to know it was a meeting, and we need to know either that a special meeting was duly noticed or it was a general regular meeting. Then, what do we need to know about the participants at the meeting? This was brought up, but just to reiterate, second step, right? Now that we've ascertained that if the meeting was not duly noticed, we're not sunk. What else can happen? Special meeting not duly noticed. How do we save that? Yes.
You ratify it later.
Yes, you could ratify it later. You could also ratify it later in a different meeting, but that meeting can still go on if, John?
People show up and participate and they don't object.
Which is effectively a waiver. So directors can waive notice, okay? Now they have to actually affirmatively waive notice of the meeting. So we have to have, first off, the meeting, this is meeting rule. So by the way, this goes on both sides, both if you're planning the meeting and if you're validating whether a meeting was correct. First thing is notice. Was it a regular meeting or was it a special meeting with notice? Or if there was no notice at a special meeting, was notice waived? And it could be waived by showing up and participating, but generally, if you want to hold it properly, you should say, look, I know, guys, that this wasn't noticed. Does everyone waive notice? And get an affirmative, yes, I waive notice, and not just a sort of silence or non-objection. It is true that not objecting could constitute approval, but it's less good than getting that affirmative consent to proceed without notice. So now, okay, fine, let's validate that. Well, one of those three ways. We either had a regular meeting, special meeting with notice, or waiver of notice. We're sitting at the meeting. What do we need next in order for the meeting to start and to run and to continue? Quorum. How do we know what constitutes a quorum? Where do we find that information? Yeah. Where's the note? Yeah. Mallory.
Oh, I was kind of gesturing thought.
Uh-huh. In the bylaws. Yes, good thought. Yes, the bylaws will contain a provision about meetings, and it will tell you how many members is needed for a quorum. It's usually a majority of the directors, but that can change. So ideally, we have a copy of the bylaws, and we can determine whether or not the quorum requirement is met. Now, let's say that there are 9 directors, and it says a majority is a quorum, and 5 people show up. Do we have a quorum? Math guys, I know it's late, whatever, it's like mid-November here. Yeah, but okay. 9 people, quorum is a majority, we have 5, do we have a quorum? Yes, we do. And then someone goes to the bathroom. What happens? You lose the quorum. This literally happened to me. I was on a conference call. I was the secretary for a meeting. We had 5 out of 9 members, and someone said, oh, excuse me, I got to go to the can. Verbatim. Yeah? I mean, people talk like this at a meeting. Sorry, I got to go to the can. And then they keep going and said, all right, let's move on to the next matter, approving blah, 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 stock issuance. And me, like first-year associate at the firm, hit unmute, because you're on mute the whole time, if you can stay that way. And I said, I'm sorry to interrupt, but we can't conduct any more business until Bert returns from the bathroom. Because we don't have a quorum, right? Because the quorum is not, this is different rule for stockholder meetings. Stockholder meetings need a quorum to start, but we don't keep track of it afterwards. One guy leaves the room, or this happens more and more often with electronic communications. You're on Skype or whatever, and someone fuzzes out on Skype. That meeting has to stop until they come back online, or the meeting is invalid. If there is any action taken without a quorum is invalid. It can be ratified later, but it's not valid. All right, then let's say we have a quorum. So we have notice, we have either a regular meeting or a special meeting with notice or waiver of notice of a special meeting. We have our quorum and no one's in the bathroom when the vote is taken for this. What constitutes a valid vote? How do we know how many people have to vote? Where is that found? Mallory? In the bylaws. The bylaws have all the rules for how the meetings work, right? So it's going to have all the rules for how the meetings work. It's going to tell you how many people you need to have a vote. Great. And so we just count the votes. Do we have whatever is required, majority, supermajority, etc. And so that should all be in here. And the secretary should certify that. Now there's an exception. The exception to the meeting rule is if we have unanimous written consent of all the directors. So, let's just say this says on the top, unanimous written consent. Robert Abel, Ramona Best, Richard Korn, Royce Dupree. Is that valid?
It would still need to be certified by the secretary.
If the secretary says it's valid? Well, what do we want what exactly would we ask the secretary to certify? Yeah. Are all those the members? Are those all the members? What if there's, I don't know, what am I up to, E? Ebert Edelson, right? He's not here today, right? We need to know. I mean, this is only a unanimous written consent if everybody signed it. That's what unanimous means, right? So if there's a fifth director, how do we know there's not a fifth director? We ask the secretary to certify to that, or we ask for other approval of that. And so, this would have worked if this is unanimous written consent or at a meeting without a notice. But, as pointed out, even if we had all those elements met, which we don't, there's still a question of whether or not this particular transaction was approved. We're getting a lot more confident. All right, so the secretary then gets up and says, okay, fine, I will provide you with some additional information, and then the secretary provides this certification. And this might address your concern too about not recognizing the constructs, right? There's a better resolution. All right, how are we feeling about this? Is it okay that the meeting was waived? Yeah, Mary Beth.
Oh, I see one right up. I mean, is it okay with bylaws to meet by Skype?
Okay, so that's a fair point. That's a fair point. Almost all modern bylaws, and the Delaware General Corporation Law says that it is permissible to meet by telecommunication unless the bylaws specify otherwise. So in that particular, I actually would not raise that issue because of the change in Delaware law. That sort of puts the burden then on them to show that was not approved, but it's reasonable to believe that a meeting by Skype was okay. But absolutely something to think about, to write about, to bring up, because it's not necessarily okay for all corporations. Yeah.
I'd say no, because it should be George Kraft, not Charles.
Yeah, the name changed. Good catch. All right? This isn't the same guy. So that's a question. That's kind of weird. Maybe his name is, George something Kraft or something. But that's another serious question mark. Right now we have an approval, and there's a discrepancy in the name, George versus Charles. There's in fact another issue on the face of the document related to that. What is Kraft author? Whether it's George or Charles, right? And that's an issue. Good catch. Close reading. What is it authorizing Kraft to do? It's authorizing Kraft to guarantee it. That sounds like a personal guarantee. Is Kraft, this language, right, we're trying to write a good resolution here. If we could write a better resolution, we would change this. And we would say that Kraft is authorized to guarantee the company. What is this, a personal guarantee? I mean, this is a bit weird. It's poorly drafted. Now, for this reason, practice pointer, if you are dealing with a company which is this crappy at their records, What you do is you write the resolution, you send it to them, and then you say, have your board approve this. So at Fenwick, when we did major mergers and acquisitions, we would buy like little dink-a-dink companies that were worth, not nothing, but 10 million, and you'd have, on the other hand, literally like Microsoft, right? We represent Microsoft, Uber, these companies are mega billion companies, and you have the rink-a-dink $5-10 million equi-hire when you're really just basically buying a team of people and 3 patents and no product, and they have no counsel on their side, and they're trying to get by as cheaply as possible. So how do you make sure the deal's done right? You write the resolutions for them. You tell them exactly what you need approved, and you ask them to have the meeting and approve exactly those resolutions. And here, we would want to include, in addition to that, is for constructs, that the guarantee is on behalf of the company. The company he's authorized to guarantee the company.
Do the minutes have to be approved by the board?
The minutes do not have to be approved by the board. Yeah. The secretary can share those. And as I mentioned, we still have the problem of who's the secretary and is this valid? But we're going to kind of leave it at that, right? We're going to be comfortable at some point. And so we haven't quite gone far enough, and I don't have yet another slide, but all those points brought up are right. And we want to figure out, who is this Kraft guy? Is it Charles? Is it George? Why is he personally guaranteeing this? Is that language? The language is just off. But it meets the other kind of aspects. It's okay that notice was waived. It's probably okay that it was by Skype. We might check the bylaws and see if there's an express disclaimer of virtual meeting, but it's probably fine. Would it be better if the contract were attached? Yeah. Would it be better if there was a recital that said, whereas the board has reviewed the agreement attached here too as Exhibit A? Yeah, there are ways to make this better. If we were writing this for our client, we would want this to be as clear a grant of authority as possible. That's why we're not going to just stop with, it's probably actual authority and move on. Really what we're going to do is try to push to the extremes of getting the most express grant of authority possible to make sure that we're not going to have any problems down the road. Our job as corporate lawyers is to put the litigators out of work, right? Our job as corporate lawyers is to avoid litigation and to avoid the sort of problems down the road by having things kind of buttoned up. A lot of expressions you'll hear around the corporate law office are belt and suspenders, right? The idea of extra protection. You don't obviously need a belt and suspenders to keep your pants up. You just need one of the two. But you might have both, even though it's a fashion faux pas, because it's extra protection. And so the idea is to just have as much grant of authority as possible. Are we going to stop here? At some point, your client's going to be like, look, just do it already. It's just a guarantee. It's fine. I'm comfortable with some amount of risk. We started with 90% risk, and we've moved to 90% safe. And how much is it going to cost to get the other 9%? We're never going to get to 100%. Okay, that's the other thing too. In corporate law, you have to be comfortable with some degree of uncertainty, some degree of risk. All businesses have risk. So how much risk are you going to take? I don't know. It depends on what your clients want to pay. You could take this another step. You could say, look, there's a couple open issues, but I think we're okay. Yeah.
It kind of go along with the culture too of business.
Yeah.
You would probably turn people off if you asked.
Oh yeah, people are like, the lawyer asked me for another thing. This is obnoxious. Just forget the whole thing. So it's really important as an attorney not to blow up a deal. So there is that sensitivity there. But you should probably at least make your client aware, look, I have not mitigated the risk completely. But in my judgment, I'm okay with it anyway. So, and that's the other thing too. The other thing clients hate is, there's 10% risk, but you decide. Clients go, it's not my job. I'm not the lawyer. What am I paying you for? Right? You're going to have to come out there and say, I'm okay with this risk. It's on me. I'm going to take it. I'm not. You're going to have to get that sensitivity. And it's a challenge. It's a much different challenge than coming up with some awesome argument in litigation. It's much more people-focused. Yeah, Paul.
After jumping all through all these hoops and getting annoyed, can you just say, we want a guarantee from construction, whatever that name is, and then they can get one from Home Supply?
Well, Construct is a company that apparently doesn't think they can pay their bills, so they're getting the surety because basically you don't want to do.
But we asked for one originally from Construct, so couldn't they just give us one if they got one from Home Supply?
Well, we'd have to know they really got it from Home Supply. Let me give you an example, right? Let me give you an example. You go to the Ford dealership, I don't know, pick your favorite car company, Porsche. You go to the Porsche dealership, yeah? And you say, I'd like that 911 Turbo for $120,000. And Porsche says, I'd like to run your credit report, sir. And your credit report comes back $592, which, by the way, is not very high. And certainly not enough to get a $2,500 a month lease on a student salary, or whatever a Porsche 911 lease goes for. But you really want the car to say, okay, fine, we really want to sell you a car, we've got a promotion, discount, whatever, but we're going to need someone to guarantee that they'll pay if you don't. So your dad comes in, and your dad's a big shot, and he makes $1 million a year at the law firm downtown. And, you'd say to Porsche, let's say your dad doesn't come in, well, my dad will guarantee it. In fact, here's a piece of paper that said my dad will guarantee it. Should Porsche sell you the car? No. No, they should get your dad in there to sign it. They should verify from him that he actually manifests that intention. And likewise here, we really shouldn't rest on just the certification of big machines. All right, so to summarize this lesson, before we move on to sort of kind of a recap of formalities of board actions, a couple more hypos. How do we ascertain corporate authority? Where am I going here? Right? We look at statutory law, the articles of incorporation, the bylaws, all these steps. And so, they're not necessarily going to be in a rote sequence. It depends on what information is coming in. But this is exactly the type of hypothetical situation. So you should go back, and if you haven't, familiarize yourself with the facts and the analysis and in Menard versus Dage MTI and in Lee versus Jenkins Brothers, because those two cases explain when you should be asking for more authority, because they will show you what is an ordinary and extraordinary transaction. Those cases are close to the line, but you should be very familiar with where that line is, and you want to stay far away from it. You want to make sure your client is protected. And so when you see a situation where there's a chance that there's not some apparent authority, even a chance, we're going to want to find a grant of express authority. And we're going to go through the process that we just went through now of getting to that stage of feeling comfortable that we have authority. All right, so what's up for after? So we have a Thanksgiving break coming up, and so when we get back, we're going to talk about the formalities of board actions. And so that's predominantly going to go over the meeting rule, which we have discussed. And so it's going to be a review and sort of putting up on the screen. We're going to talk about how directors have one vote and cannot act through proxies. And so that's going to kind of cover our formalities of board meetings, and then we're going to talk about the exceptions briefly. Just to give you a preview, there's a certain type of corporate you can file as a close corporation. They don't have to necessarily have meetings. We have the unanimous director approval. In some cases, the shareholders themselves can approve, and there's some emergency provisions as well. We talked about notice, quorum, and voting, and so we're just going to recapitulate that, and then we're going to spend the rest of the time going over what are called legal opinions. And legal opinions are the most complicated of the topics. If you haven't caught up on it, refresh yourself before you come on Wednesday and look at that. We're going to step through all of the attributes of the legal opinion in your book, and we're going to talk about it in detail. But a legal opinion is critical as a capstone to the entire concept that we've learned of all of this. Because a legal opinion is when the lawyer says, I certify that this transaction is authorized. And, in fact, the attorney is going to then be legally liable if that's not true. So you may be writing these one day, and it is sort of the capstone to the concept of agency and authority. Now that you understand the theory of agency law and how authority can come either through express grants or apparent authority or sometimes inherently, and then your job is to ascertain that authority by looking at the bylaws, by asking for resolutions, by getting certificates from the secretary, then you will actually potentially have to opine on that authority. And so I hope that it'll be kind of a nice capstone discussion because it's going to bring up all the concepts that we've learned in a sort of review type of process. And so that'll be our last substantive class after Thanksgiving break. And then the next class after that, our last actual meeting, will be an open review session. So come in with your questions, concerns, anything that's still unclear from the course. And that'll be a nice opportunity for you to ask anything of me that you want to know for the exam, and I will tell you anything other than the exact questions that are on it. My idea here is transparency. As I discussed, the first 5 questions will relate to choosing which organizational form. The next 5 questions will be to forming a Delaware C corporation, and the next 5 questions, 5, 5, and 5, the next 5 questions are going to pertain to determining whether a corporation is authorized and or asking for additional evidence of authority. And the legal opinion stuff is not tested on directly, but it's a review and a recap of everything that we have learned so far in this chapter and over this 3-week period. So please refresh your recollection of that. If you haven't looked at the Menard first stage case carefully, and you haven't looked at the Levers Jenkins Brothers case carefully, it's worth your while to refresh it, because it'll give you a sense of what kind of cases require this type of analysis, and what is the difference between ordinary and extraordinary. So have a great Thanksgiving break. I will see you in 2 weeks.